We will give it just a moment to let people trickle in. If everyone could go ahead and mute their microphones, that would be great. All right, we're going to go ahead and get started. Thank you all for joining us at this lovely webinar on client-directed representation for children. I am Dr. Stef Sloan. I am co-director of the Child's Voice Project, where we are trying to improve outcomes for children, families, and the courts by amplifying the child's voice in complex custody cases. Welcome, everyone, and thank you so much for joining us today. This webinar is sponsored by the Child's Voice Project, so you will be sure to hear that name a couple more times, I promise. And your job as attendees is to get really excited every time we say the Child's Voice Project. Again, I am Dr. Stef Sloan. I will be moderating the panel today, and our speakers are, we are joined by Liberty Aldrich, and Liberty is a retired judge and is the executive director of the Children's Law Center, and she will be presenting for us today after Suzanne. Suzanne is our co-director of the Child's Voice Project. She was also the director of the Child's Advocate Program in North Carolina, and she has a long history of representing children in complex custody cases. We are also joined by Cathy Tempesta, and let me see, I lost my little program where everybody's names were on here. So give me 1 second for me to pull that up. And we're joined by Cathy Tempesta and Dr. Mike Saini. I don't want to hold everybody up looking for my paper that disappeared right off of my desk. So I am going to, next slide, please. Just give you a little bit of a heads up on some of the procedures and protocols today. We will be holding questions until after the moderated panel. So we're going to start with presentation. We're going to have some moderated panel discussions, and then we will start taking questions from the audience. You are welcome to put your questions into the chat, and you're also welcome to hold your questions until the end. I will be compiling questions as we go through. Next slide, please. All right, with that, I'm going to turn it over to Suzanne Chester to begin our presentation.
Suzanne, you're on mute for me. I don't know if other people can hear you.
You get on the van.
Can you hear me? Can you hear me?
We can hear you.
Oh, great. Hi, everyone. This is Suzanne Chester from the Child's Voice Project. Some of the goals of the Child's Voice Project are to promote client-directed representation for children and family court involved in very complex custody cases. And our plan is to do that through 3 different venues: through education, through research, and through piloting a legal program providing attorneys to children in states with supportive legislation of that role. So the client-directed model is based primarily on the ABA standards for lawyers representing children in custody cases, and I'll be referring back to those standards throughout. Also, at the Child's Advocate, which is a project of Legal Aid of North Carolina, I directed the program for the past 10 years, and along with my staff, we really developed a trauma-informed and child-centered model in addition to the standards under the ABA. The attorneys that we promote here at Child's Voice Project are really trained in the substantive areas related to the issues that come up in these cases. For example, domestic violence, child maltreatment, issues when one parent rejects a child's sexual orientation or their gender identity. We train attorneys in child development, in communicating with children in a developmentally appropriate way. Next slide, please, Ariana. So I think before we get into any more detail about client-directed representation, let's take a look at the three main models that are out there in terms of legal representation for children. Let's start with the first one, guardians ad litem. Probably everybody attending is familiar with that role, which is maybe a lawyer, doesn't have to be, could be a mental health professional. And the GAL investigates, writes a report or testifies at trial. And primarily the important thing to remember about a GAL is the GAL recommends what they believe is in the child's best interest. The rules of evidence don't apply, and oftentimes there may be significant hearsay. Then the other two models that we'll be looking at are the two models identified by the ABA standards and that are present in some states and not in others. There's the best interest attorney role and the client-directed attorney role. Both roles require that the person be a lawyer. The best interest attorney acts as an attorney in court, just as the client-directed attorney does. For example, they present witnesses, they call witnesses, they get to cross-examine, they make arguments in the courtroom, just like a parent's attorney, if the parent is represented, does. A best interest attorney doesn't write a report and doesn't testify, and the rules of evidence apply. The huge difference between client-directed counsel and a best interest attorney is, again, with the best interest attorney, that attorney substitutes their judgment for what is best, for what they think is best for the child. By contrast, a client-directed attorney advocates for the wishes of the child. And so that means really getting to know the child well and understand the reasons behind their wishes. It's a confidential attorney-client relationship. They're bound by the rules of professional conduct and by the rules of evidence. And very importantly, they owe a duty of loyalty to the child. For example, in a case where there's an allegation the child has been coached, it would be contrary to the attorney for the child's duties to start saying to the other professionals, well, I really think my client has been coached. That would be a betrayal of the child, because the job of the client-directed attorney is to advocate for the child and to seek to understand, rather than jumping to a conclusion as to whether or not the child has been influenced. A client-directed attorney goes by different names in different states. Under the standards, it's called a child's attorney. I know in New York, it's attorney for the child. In Maryland, a child advocate attorney. And in Texas, attorney ad litem. And a best interest attorney may be called minor counsel. I know in California, a best interest attorney is called minor counsel. And so there are a lot of different terms for these different roles. Next slide, please. So with client-directed representation, the duty of confidentiality is super important. And as children's attorneys, it's our job to explain to our clients what confidentiality means. And obviously that means doing it in a developmentally appropriate way. I always remember a case where I was representing a young boy who was about 10 years old, and I had gone through what I thought was my developmentally appropriate spiel about confidentiality. And he looked me in the eyes and he said, "Will you pinky swear not to tell my mother that I want to spend more time with my father?" So much for strict confidentiality in legal terms. It was a wonderful way that showed that he had really understood what I was talking about. A large part of being a client-directed attorney is to develop rapport and trust with the child. And that really means getting to know them through multiple meetings, through talking with other adults who know them well, and consulting with their therapist if they have one. That can be really useful and important so that we get to understand the child's perspective, what their objectives are and why they have those objectives. Another really important part of our role is, just like attorneys who represent parents, we have to advise our clients. We have to provide them with legal counsel throughout the case. So we don't just parrot what our clients tell us they want. We go through a process of counseling them. We explain the chances of whether their goals are achievable. But bottom line, we are duty bound to follow what their wishes are and to advocate for their wishes. So that means that we need to be really careful about the power dynamics that are involved in an adult-child relationship. Most children are likely to say yes, especially younger children are likely to say to an adult what they think the adult wants to hear. And so as we counsel our child clients, we must be careful not to override the child's wishes in the process. The next slide, please. So the child's advocate at Legal Aid is where I spent the last 10 years, from 2014 until the end of 23, directing the program. In North Carolina, in the counties that we served, the judges would appoint an attorney for the child. They believed that it was in their inherent authority to do this, to appoint an attorney for a child if it would help the judge to decide what the child's best interests were. We provided services to children aged between 9 and 17. Those children came from all economic backgrounds, some very poor with pro se parents, some from wealthy families. We limited the cases that we would accept to cases which involved at least one of the list of issues that you have there in front of you. Typically, these cases are referred to in the court system as high conflict, and these are the typical issues that we would want to see in a case before we would be able to be appointed to represent the child. The next slide, please, Ariana. So very importantly, when a judge is appointing an attorney for a child, it's really important that the appointment order clarifies what the role of the attorney is. Is it going to be a best interests model, or is it going to be client directed? In order to be able to provide trauma-informed and child-centered representation, it was really important that the child's advocate, and we continue to do that at Child's Voice Project, to be really trained in these areas that come up in our cases: domestic violence, child maltreatment, resist, refuse dynamics, cases where there's allegations of parental alienation, children with special needs, and communicating with children and understanding. A large part of our training was working with children's therapists, so we would know how to speak to a child who had experienced trauma in a way that would not be triggering for the child. Next slide, please. So I'll finish up here by saying that we also put a lot of emphasis on making sure our representation is culturally appropriate and responsive to the child. And we really do try to take a humble approach. We don't go in there thinking we know what's best for the child and trying to shift things around to that result. We really try to be humble. We know, I think it was Anne Haralambie has written an article about the fact that children are experts on their own lives. And we really advocate for that view, so that we go in there as we represent the child, trying to learn about the child's views and perspective. Additionally, in our role as attorneys, we ensure that the child's perspective is really kept in mind throughout the litigation. Let me see. Stef, I think I am done now, so I am going to turn over to my colleague, Liberty Aldrich.
Hi, everybody. I am not sure, Steph, are you gonna pull up my PowerPoint and then, I'm sorry, I don't have it.
Yeah, I can grab it real quick.
Thank you. I mean, I could do it as well, I guess. I could do it. That's fine. So, hi, everyone. Again, I'm Liberty Aldrich, and I'm so glad to be here. I'm very curious about folks who are in the audience and who's here with us today. And so really looking forward to the discussion so we can hear your questions and, you know, what's particularly of interest to you, because I'm sure people are here with all sorts of different goals and perspectives. So actually, here I am, I'm sharing my screen and can people see this?
Yes.
Okay. So I am really looking forward to hearing from all of you, because that's probably more interesting than what we have to tell you. I will just start by saying that the Children's Law Center our mission is to advance the rights of children in legal proceedings that involve most of the issues that Suzanne just mentioned: custody, visitation, domestic violence, and child protective issues. In addition to representing our clients in the courtroom, we also work in the community, and we do so with the goal to empower our clients, reduce the negative impact of both family dissolution and court involvement, and to promote well-being and equity for our clients. I think more folks in traditionally are familiar with an attorney for the child role in child protective proceedings. We at the Children's Law Center focus on representing children in custody, contested custody matters that have in many ways, many of the same issues that might be found in child protective issues, such as parental death, housing instability, drug, alcohol use, mental illness, and other family disruptions. And we believe that an attorney for the child can make all the difference in our clients' lives. The Children's Law Center has been in existence since 1997. We've represented more than 135,000 children. We're currently representing more than 5,000 children in family courts in New York. And we've pursued more than 1,000 appeals on behalf of our clients, really setting a lot of law in New York. One thing you know, again, these are the kinds of cases that we handle in New York. We do both trial advocacy as well as appellate work, and we have social workers on staff who conduct risk assessments, who work on our clients' educational needs, and assist with mental health referrals for, unfortunately, many of our clients who are struggling in multiple areas. We also partner with folks in other legal services programs and assist on immigration proceedings or other related matters. We represent children 0 to 21, so with the vast majority being between 5 and 13. So we don't have an automatic cutoff, but we do say that our preference is for children 5 and above. And we do go up to 21 in the case of guardianship proceedings. In New York, the majority of our cases are from the Bronx and Brooklyn, which are Also, we represent primarily people who cannot afford attorneys. About 95% of our families are qualified for appointed counsel, which means that they are not able, the court has determined that they are not able to hire an attorney. I know I'm in a sort of double duty also as a judge. So I'm gonna probably not go into my, Suzanne, my judicial decision-making so much, because I think we will talk about that a little bit more in the panel. But I did want to say that, sorry, I'm now gonna stop sharing. Yikes. We in New York, unlike I think almost any other state, we actually have a right to counsel in family court in all matters, including custody visitation matters. And we also have a rule of the chief judge that all attorneys for children are advocates for that child. They are not best interest attorneys. We don't have that in New York anymore. You can have a GAL if you have someone who is incapable of making a decision, but that is not the function of the attorney for the child. So anyone, I put the rules of the New York Chief Judge in the chat, or at least the name of it, if you want to find that. It lays out what the ethical duties of an attorney for a child is. In New York, unlike what Suzanne said, if we feel that the child is unable to formulate a position because they are under so much pressure, we can substitute judgment for that child. But again, that is only if we've made a determination that they are incapable of coming to an independent position, and then we would inform the court that we were substituting judgment. So I can go into the judge stuff more when we circle back. I'll kind of take that role, but I think I'm supposed to turn it over to Cathy next.
Thanks, Liberty. Okay, so I'm now going to try and upload my PowerPoint. Just give me a second here. Okay. And okay, here we go. So as Stef indicated in the chat, I'm with the Office of the Children's Lawyer, which is an independent law office within Ontario's Ministry of the Attorney General. So we are a government office and we're publicly funded, but we're independent insofar as the positions that we take on behalf of our child clients. And our office represents and assists with respect to the personal and property rights of children in certain proceedings before the courts and tribunals of Ontario. And our program's been in existence for a long time. It actually dates back to 1881 in terms of protecting the property rights of some children. And then our child representation program, which is more in line with the program today, really came into effect as of 1980, where lawyers began to be assigned for children in parenting and child protection matters. So we represent or assist children from birth to 18 years of age in child protection matters, in parenting cases, and in certain estates and civil litigation matters. And we get involved by way of a court order. So we can't just begin to represent a child on our own initiative. There has to be a request from the court for our involvement. And we have a standard form order that we use and that we request the courts to use, which indicates that if we are providing legal representation to the child and the child has all the rights of a party, which includes our ability to make a full and independent investigation into the child's circumstances. It means being able to get copies of all reports and records relating to the child. It means that we have the ability to appear in all court proceedings and have the ability to examine and cross-examine witnesses and make submissions on the law on behalf of the child. It means that we can take appeal proceedings on behalf of the child and that we can seek costs in proceedings as well, although we don't do that very often. In terms of how we're set up, so we have lawyers, as I've suggested, and at our head office in Toronto, we have about 80 staff with 13 in-house personal rights lawyers. So those are lawyers that represent children and family law and child protection matters. 12 in-house property rights lawyers. And then we also have a clinical department with 11 regional clinical supervisors, social workers primarily. And then in addition to the in-house staff, we have lawyers and clinicians across the province who are in private practice and who do work on behalf of our child clients on a fee-for-service basis. So we have about 350 lawyers that we call panel lawyers and over 200 clinicians that do the work on our behalf. And the staff in Toronto at the head office provide orientation and training to those panel members, including formal and informal supervision. We are the most expansive child representation program in Canada. And so we have the ability to represent a fair number of children, although not all, because unfortunately resources are not unlimited. So in 2023, we provided services to over 7,500 children in parenting cases. And about 7,500 children in child protection, adoption, and post-adoption openness proceedings. There are no income criteria in terms of the involvement of our office, so we do serve children and families from all socioeconomic backgrounds. The Office of the Children's Lawyer has been recognized as a model for other jurisdictions in promoting access to justice for children by ensuring that children's views are heard in court processes. And our courts have held the Office of the Children's Lawyer to be fundamental to the proper functioning of the legal system, given its unique role in representing children. And as mentioned, we only become involved when there's been a court order requesting our involvement. And in the child protection context, we have no discretion when we get these orders. We have to provide a lawyer for the child when the court requests it. There are certain criteria under our child protection legislation that guide the court in terms of when it's desirable to have a lawyer for the child. And in Ontario, children who are 12 or older are entitled to receive notice and to be present at the hearing in a child protection case, unless the court finds that it would be emotionally harmful for the child to have that notice and to be present. And the opposite is true for children under 12, that they're presumptively not going to be there unless the court is satisfied that the child is capable of understanding the proceedings and wouldn't suffer emotional harm by being there. And in the child protection context, the child protection statute actually indicates that a child who has legal representation is entitled to participate in the proceeding and in any appeal as if they were a party. In the child protection context, in addition to representing children in child protection proceedings initiated by children's aid societies, we can also and do provide independent legal advice to children 7 and older in terms of adoptions and witness their consent. We also provide legal representation and advice to minor parents whose children are being adopted. And we may also, as I indicated, represent children in post-adoption openness matters. And we may also represent children in pre-court and during court ADR processes. In the parenting context, if a court makes an order for our involvement, we actually have discretion as to whether we will accept or reject the case. And again, as much as we would love to be able to represent every child who's the subject of a parenting dispute, resources unfortunately limit our ability to do that. And so we do have to reject some cases that are referred to us. When we do accept a case, there's different types of services that we can provide. So one is legal representation, as I've mentioned. Another type of service is a children's lawyer report, which would mean assigning one of our clinicians to do something akin to a custody access assessment, where they investigate the circumstances of the child and then make recommendations on the parenting arrangements. Alternatively, one of our newer services is the preparation of a Voice of the Child report, where one of our clinicians would meet with the child on 2 occasions, write a report that contains the views of the child on the issues before the court. And it's a non-evaluative type of intervention. So the clinician is meant to relay the children's views as closely as possible to the way that the child has expressed them, without weighing in on whether they're independent, whether they're in the child's best interest, etc. If the service that we provide is legal representation, there's the possibility that the lawyer can request the assistance of one of our clinicians. And so we might do that if it's a really difficult case where there appear to be clinical issues and we think we could benefit from the input of one of our clinicians. Another reason to have a clinician involved is to have a mechanism by which to put evidence on behalf of the child properly before the court. So that would include evidence of the child's views, as well as any relevant circumstances of the child that support the outcome that the child would want. Because our courts have said that as counsel, we cannot simply put the child's views before the court from counsel table. There has to be a proper evidentiary means to do so. And generally in family court proceedings, as I suspect is the case in the US, courts are not keen on having children testify directly in these cases. So as with what Suzanne was discussing in terms of her program, a lot of our cases are pretty complex and involve overlapping issues regarding mental health challenges for our clients or their family members, family or intimate partner violence, substance abuse, alleged abduction, either domestically or internationally. Allegations of alienation appear in just about all of our parenting cases. Children with special needs, children or family members with precarious immigration status, and a lot of younger children. And I'll talk about this more in our discussion, but the role that we take on behalf of our child clients is a rights-based instructional advocacy approach. And that approach is grounded in children's rights under the UN Convention on the Rights of the Child. And Canada is a ratifying party. And as you probably know, the US is the only country thus far that has not ratified the convention, although you are signatories, which means in theory, as a country, you're meant to not engage in acts that would defeat the object and purpose of the convention. So one of the key issues that we bring forward on behalf of children, obviously as their lawyers, is their voice in court proceedings and ensuring that children's views are meaningfully considered in best interest determinations that are made in family court processes in a way that's not tokenistic. And if we're looking at representing younger children who are not yet verbal, or children who, because of their developmental stage or issues, are incapable of instructing, then the approach we would take is to advocate for their legal interests. So I wouldn't call it a substituted judgment role. It's more where you would inform yourself of the child's circumstances by speaking to parents and third parties, schools, doctors, mental health professionals that may have information about the child. but taking a position that is not based on what the lawyer's personal view of the child's best interest is, but a principled approach based on the evidence, and arriving at a position that, to the extent possible, maximizes the rights of the child and a decision that the child would make if he or she were capable. So with that, I'll leave it and pass the torch on to Michael Saini, and I look forward to the discussion after this. Thanks. And I will stop sharing. Here we go.
There we go. Good morning, good afternoon, depending where you are. It's a pleasure to be here, and thank you very much for involving me in this discussion today. I think whenever I have the opportunity to speak to the importance of children's voices, I like to jump on it because it is a great topic, and it's really important that we are considering children's voices. And I think those are three great examples of how we can engage and listen to children in a more authentic way. So I'm going to just spend about 10 minutes as we go through some of the empirical research. Most of the empirical research, as you would expect, is based on qualitative interviews with children. That is the preferred methodology for listening to children, is actually to engage with them in research where we're asking them questions about what they want from the courts, what they want from professionals, what they want from the process, what are their expectations, and what are their experiences, and how do they think this impacts them overall in terms of their involvement. I want to first start off by putting this into context where it's not too long ago where children were seen but not heard, and that was the sort of the idea of children's voices, is that they were not listened to. We did not prioritize children's voices. We did not want to hear about their experiences. In fact, we felt that engaging them in those discussions would only be harmful, and that we needed to protect them, and we needed to be ensuring that their best interest was met, but that did not include listening to their views. Here in Canada, the Divorce Act was amended just a couple of years ago, and finally now includes children's voices as being one of the best interest tests. And that is a huge step forward for children's voices. That way they're less likely to be suppressed within a context, within a system that has not necessarily listened to children and has not included children's voices as decision-making influence on what we suggest should be happening to their lives. And so this has been changing with the UN Convention, has been changing with research that has specifically been dedicated to listening to children's voices. It's also been changing with our better understanding of child development and the impact of engagement and the impact of being empowered to have a voice, and what does that do for one's feeling of agency. And so we now more recognize the importance of children's voices. In fact, we've now moved into a discussion of not whether or not children's voices should be heard, but how do we go about listening to those voices? So as was mentioned, the rights of the child to be heard in all matters that affect them. And unfortunately, even within the context of family law, most times children don't have a voice unless their parents take the matter to court. And most of our services, I do voice of the child reports. I speak with children outside of the context of court, but there's very few opportunities to listen to children's voices unless they're going through litigation. And there's been more movement towards child inclusive mediation and parenting coordination, child inclusive services. And so we really need to be thinking outside the box as we look to provide every child the opportunity to have their voices heard. This is one study that I did with AFCC and NCJ/FCJ, where we did an interview, where we did surveys over 1,000 professionals. And part of it was a list of questions that got at potential views around this term parental alienation. And then from there, broke it into proponents and opponents based on one standard deviation away from the mean of responses, and found that whether you are a proponent or an opponent of this concept of alienation or parental alienation, it will have an influence on what weight that you give children. And so proponents were more likely to give less weight to children's views in the context of parental alienation allegations, whereas opponents were less likely to agree with that. And if you were an opponent of alienation, you were more likely to agree with empowering children to have a voice. And this is problematic because this is one of the barriers of children's participation. We must listen to all children, whether or not we like what they have to say. And it may not be the lyrics, as Mindy talks about, but we at least have to hear the songbook. We at least have to understand where they're coming from. We don't have to agree with them, but they need to be part of the picture. And they have a lot to offer us. Children are silent observers in their family context. They know things about the styles of conflict resolution, the parent-child relationships before and after. They have information about what they do as a family or with their parent, the sibling relationships. You know, they have so much information to provide us in terms of how they are experiencing the separation. And it's really important that we spend the time to speak with them. By and large, research has shown and continues to show that children want their voices heard. They want to have a say in matters that impact them. They want to be safeguarded by professionals, so they want to be able to express their views in a safe way. So having these clinics, having these opportunities to provide their voices in a safe way is the preferred approach, rather than having to tell a parent who may or may not feel that the parent is able to listen to their views and concerns. And so the opportunity to be able to speak with a safe professional who is going to hear their voices is so critical. It's really important that we distinguish between voice and choice. I like this picture because it really represents, you have an apple and a donut, and I feel that same way many days. And so the idea here is that, you know, we want all children to have voice, but it doesn't mean that they get to choose in the decision. I like to explain this when I'm speaking with children. It's like a pizza, because most children like pizza. Every slice is an important voice that makes up the narrative of views. And if you were to get a pizza delivered to your house and you had a slice missing, you would feel that that is wrong. And that's like having a situation where children's voices are not part of the big picture. It's like having that slice missing. Just like if the whole slice was the child and that no one else had a say, that wouldn't be right either. And so voice versus choice, children have a right to be heard within the context of age maturity. And this is where we need to have professionals who have children's best interest and really authentically want to hear children. Children don't want to choose between parents most often. They don't want to hurt or upset parents. They don't want their parents to be worried or sad, and they are afraid of making the wrong decision. And so putting children in the middle of their parents is not necessarily in children's best interest to give voice. I always say to evaluators who put too much emphasis just on children as their best of evidence to support their hypotheses, go get better evidence, go get different evidence, go triangulate the evidence. Don't put so much pressure on children as being the source. So having children involved, there's many positive impacts. They feel empowered. They gain a sense of agency. It leads to better decisions. Children can better accept the ultimate decisions because they know that they're part of the process. It's not as confusing. Many children say they have no idea what's going on. Their parents go and they talk to other people and they have no idea, or they talk to a bunch of professionals. The one thing that I've noticed talking to kids is that, you know, I make a big difference between a social worker and a lawyer and a judge. But for kids, we all look the same. They have a really hard time differentiating, you know, who we are. So if we have child protection talking to them, police talking to them out of uniform, we have a social worker talking to them. It's just all these people talking. They have no idea who's who. And so being clear and transparent about the work that we do with kids is so important. And so all of this can lead to better relationships because they're able then to impart their wisdom onto us. It's not good for kids sometimes when it's emotionally overbearing on them, when they're put in the middle to choose, when their views are influenced or manipulated by adults. Or when it's tokenism. We want to hear them just because it's like a checkbox that we do, but we really don't mean to use what they have to say. We're just listening because we feel we need to. So at the core principles of child-centered approach, which I think from what I'm hearing from the three examples so far, if you were to do a checklist to see how they're meeting up to these, you would see lots of agreement here regarding prioritizing child welfare in all decisions, recognizing children as individuals in their own rights, not children in becoming, but children are humans now with concerns and fears and wishes. Always act in the best interest of children, actively involve in them in the decision-making process, foster a sense of autonomy and confidence in children so that they feel better able to communicate and have their voices heard. You know, the one thing that we're teaching kids that we often don't talk about is how to communicate. If their parents are arguing, they haven't been able to be exposed to good communication and the ability to have your needs met and expressed in a way that is going to optimize that opportunity. And so by speaking with children and allowing them to communicate their feelings, we're giving them the opportunity to think about what they're thinking and then to share it in a way that it can be understood. And of course, a child's voice, and I love this quote from Professor Dumbledore. Dumbledore gets the last word. A child's voice, however honest and true, is meaningless to those who've forgotten how to listen.
Thank you so much to all of the presenters, and for their bios, please take a look in the chat. You can see how incredibly talented and informative and all of the amazing work that these folks are doing. I would like to shift now to asking the presenters some questions. Liberty, you have the first question. As a former judge who presided over custody cases, Why did you believe it was important and appropriate to appoint an attorney for the child in certain custody cases?
Great, thank you. And thank you so much. I love listening to the co-panelists. So I would start by saying that I wholly agree with the pizza analogy. To me, it just doesn't even make sense in some basic way that you could proceed in a matter which is about the future of the child without having some input from the child in that context. So let me just start by saying it's very hard for me to understand a position that would be against the child's voice. But in a more specific way, part of why I believe that is because as a jurist, I am there to make a decision about the best interest of the child. I am the one responsible for making that decision. The person representing the child, in my opinion, should be doing just that, making, as Cathy said, doing investigation, finding out what issues the child is dealing with, assisting the child, and as Suzanne said, counseling the child, explaining what the likelihood impacts, but really at the end of the day is there to litigate, advocate, do everything in their power to advance the issues and wishes of that individual client. I don't, as a jurist, I didn't need another person in the courtroom speaking on the best interest of the child. I was going to make that decision based not only on the position of both parents and the child, but on evidence presented in court by any of the three attorneys. And any psychological or third-party exams that were presented. So that's my sort of role, my understanding of the role of the judge and why I felt it made sense to have an attorney representing the child rather than a sort of best interest role. But in terms of why at all, in addition to the pizza analogy, which now, my God, I'm going to use all the time. But anyway, you know, many of the cases, as everyone here has said, these are not simple matters. There are legal issues, there are jurisdictional questions, there are rights and responsibilities, as well as, you know, all the impacts that Michael said about, you know, why it's important to have a child's voice. There are legal reasons why you know, that party, that affected, impacted person needs to have legal representation. Additionally, I was seated in the Bronx Family Court, but to be honest, I don't think it's that much different. The issues of mental health, domestic violence, allegations of sexual abuse, incarceration, or absence of a parent, all of those are just increasingly frequent. Everybody you talk to says that the level of complexity and the issues that families are facing is just increasing. So for all of those reasons, I was passionately committed to appointing an attorney for the child whenever possible. Unfortunately, there's not always enough. And also, you know, there's certainly when the child's an infant, unless there are other issues, it might not be the necessary, but
Thank you so much. Cathy, the next question is for you. We were hoping that you could talk a little bit about how the UN Convention on the Rights of the Child informs your approach to representing children.
Yeah, so as mentioned, we take a rights-based approach in terms of representing our child clients. So obviously the voice of the child is central to our role as lawyers for children. You know, we are there to try to ascertain the child's views as best as we can and to advocate for a position that is consistent with those views, which is in line with Article 12 of the UN Convention on the Rights of the Child, which speaks to the child's right to be heard in all matters affecting them. And to have due weight given to those views. So we as lawyers, you know, our role is not just to ensure that the judge can tick off that little box that says, okay, now I know the child's views, but to ensure that those views actually form and inform the decision making. But the Convention on the Rights of the Child and the UN Committee on the Rights of the Child, which oversees the implementation of the convention amongst signatory countries, you know, indicates that rights are indivisible and interdependent. So you do have to look at all of the child's rights, and that includes things like, you know, the child's right to be free from all forms of violence, Article 19, or the child's right to privacy, Article 16, which is, you know, relevant in family law cases, for example, where other parties may be seeking children's counseling records, for example. And so, you know, we have to look at protecting all of the child's rights, but as Liberty indicated, as lawyers, our role is not to make that best interest determination. That's for the court. Best interest is inextricably intertwined with the child's views, and from a rights-based UNCRC perspective, a decision maker cannot properly make a best interest decision without considering the child's views. But, you know, again, at the end of the day, as lawyers, we have a role to advocate for the outcome that the child would like, because at its essence, a human rights-based approach calls on us to recognize and respect and reflect on each child as an individual distinct from their parents, and to empower them to be actors in their own destiny. And, you know, they are experts in their own lives. So that means we have to probe into each child's lived experience in order to ensure that courts and parties meaningfully consider their views and preferences in the decisions that are being made. So that, you know, at its core is what the rights-based approach entails. My PowerPoint is quite lengthy, and obviously I didn't go through the whole thing, but there's a number of slides that sort of expand on that if you're interested in taking a look at some point at your leisure.
Thank you so much, Cathy. As a child developmentalist, you are 100% speaking my language. And that brings me to my next question, which is for Suzanne. How do you find out what your clients want? I mean, I think kids can be complex, asking the right questions, figuring out, like, you know, what are they meaning when they say certain things? How do you find out what your clients want you to advocate for?
Thank you, Stef. So I would say there's kind of three main things involved, and one is building trust with the client. Two is working with the child's therapist if they have one. And three is the whole notion of confidentiality. So in terms of building trust with the client, remembering that all of the cases that we handled at the Child's Advocate and that we will be handling through the Child's Voice Project, they involve very difficult issues that the children have been involved with, whether it's child maltreatment, a child with special needs, exposure to domestic violence. It's really important that when we meet with the child as their attorney, that we don't overpromise, we don't guarantee an outcome. And if we say we'll do something, that we actually do it. And that we give, you know, the same respect to the child client that we would to an adult client, if not more. I think we build trust by answering the child's questions. I've often had clients who really didn't know what was going on and had questions that were just burning a hole in their brain that they needed answered. And I think giving an answer to those kind of questions helps to build up trust so that we can eventually figure out what their position is. Also, in my experience, a lot of my clients had already spoken with so many professionals. They may have been interviewed by CPS. They might have had a custodial evaluation done. They may have spoken to a range of different court-appointed therapists. And oftentimes they felt like nothing was really changing, especially, children who were in really serious adverse circumstances. And I think being able to let that child know that I was going to do everything I could to advocate for what they want makes it much easier to get the child to actually trust me and to let me know what it is they want. Confidentiality plays a huge role. When the child understands that I'm not going to go back to a parent and tell them what they've told me, then that makes them feel a whole lot safer about sharing it. And then working with a child's therapist makes a huge difference, especially again in these cases where the child may have experienced some trauma in the past or significant trauma in the past. Being able to talk with a mental health professional also dedicated to the child give me a window on the reasons for the child's position, and also help me to communicate with the child in a child-centered way and in a way that would more likely lead a child to opening up. Yeah, I think all of doing those things are the way that I would gradually learn what a child's position was. And sometimes a child's position may change during the course of representation, and that's fine too. It's not like, we're trying to lock them into a hard and fast position. But they would be the main ways that I would figure out what my client wanted me to advocate for.
Thank you, Suzanne. And while we are so aptly talking about eliciting the child's voice, my child needed to vocalize something to me and so kindly wrote it on a piece of paper. Thank you for your patience. Mike, my next question is for you. You wrote in 2012, you wrote an article with Rachel Birnbaum, and you concluded that decision makers really need to be hearing the voices of children and not just what professionals believe is best for children. Can you talk a little bit about your research and how you ended up with that conclusion?
Yeah, sure. So children talked about their voices being filtered by professionals. And there is a broken telephone that can occur when professionals interview children with their own predetermined hypotheses of what is in the best interest of the children involved. So what happens then is you go in with the idea of what is needed for the child, what should be the parenting plan, what should happen in terms of the safety and time and so on. And then you then filter your questions in a way that triangulates the child's stories with other information that you have. For example, if we do child custody evaluations, it's not often that I've heard of an evaluator going out and interviewing the child first to get their raw story of what's happening. Typically, the child is interviewed at a later stage of the evaluation, once the parents have been interviewed a couple of times, once they've received collateral information, once the observations have been done, once all the other steps have been taken, then the child is interviewed to get what they think. And by that time, the evaluator already has preconceived hypotheses about what may be happening, and therefore is filtering their interview in a way of either supporting or rejecting some of these hypotheses, rather than coming in with a blank slate and just saying to kids, what do I need to know from your experience? What would be helpful for the judge to know? Like, for example, having those open-ended questions of what do you want us to know? What is from your experience that you think is important for us to be able to take away from? And so being much more open-ended and less closed in our questions would provide more opportunities for children to give their voices in a way that makes sense to them and allows them to express themselves in an authentic way.
Thank you so much, Dr. Saini. You mentioned, being able to elicit information that is the most useful for decision makers. And Liberty, that brings me to another question that I have for you. Can you talk a little bit about the role of the judge when there is a client-directed attorney and how you make sense of and merge all of this information?
Yeah, thanks. I think that one of the it's interesting because there's sort of two very opposed ideas that people have about why kids' voices should not be present in the courtroom. And one is that kids are unreliable and what do they know anyway? And then the other one is, oh, the judge is just going to do whatever the kid wants, and sort of turn over the court's decision making to the advocate for the child. So similar to what the Apple donut situation, some people fear that the court will turn over decision making, and I feel that that's a large role of why, again, it's so important that the role of the attorney be clear that they are not doing a separate best interest determination, and that they are there as an attorney just like the other attorneys with all the same rights. I love what Cathy has in her order. We don't have that because, again, it's in our court rules that that's what the attorney does, but it would be nice to have everyone reminded every time, because it is, again, the judge's role is to make that best interest determination based on just the evidence in the record. And I do think that people underestimate how important it is to jurists what is on the record. That is what we're confined to consider. Apply the law to the facts that are on the record. We're not supposed to be bringing biases or bringing assumptions. And in many jurisdictions, there may be factors that the court is required to consider, maybe even presumptions, such as not placing a child with someone who has been determined to have committed acts of domestic violence. So we're applying the facts to the law and to come to a determination around best interest. That record has to be fully developed, and that is why again, as a jurist, it was so helpful to have the role of the attorney for the job.
Thank you. And it looks like we have about time for one more question. So Cathy, you're it. I'd love to hear a little bit more about thinking about the significance of weight that a child should be given. So in your presentation, you take a slightly different position than Dr. Saini's, and you refer to the significant weight that should be given to children's wishes. Can you say a little bit more about that?
Sure. And it's particularly great because Michael won't have time to respond. So, he did mention in his presentation that children should have a voice, but not necessarily a choice. And that may be true for some children. And I think the starting point is the child. What is their preferred mode of participation and how much of a say do they want in the ultimate outcome? So in a perfect world, there'd be some kind of triaging system at the beginning of a process, a court process, where a child could be informed of the various mechanisms by which they could be involved, whether they want to be involved at all. And then that would be what would be facilitated. And although some of the research says what Michael said, some of it also indicates that, in contested cases, for example, where violence and abuse are at issue, children actually do want to have a greater say in the outcome, and do want their views to potentially be what ends up happening. And there is a Cashmore study that says that. And even looking at one of the reviews that Michael did with Rachel Birnbaum, who refers to a study where it says that in cases of violence or oppression, children indicated that they should be able to make the decision on their own. So in those kinds of cases, given, what's at stake, I think there is a case to be made for children to have more weight given to their perspectives. And that also is in line with a rights-based approach. And again, the UNCRC at Article 12 indicates that children have the right to be heard and to have due weight given to their views in accordance with their age and maturity. And the Committee on the Rights of the Child does talk about avoiding tokenistic approaches. And the committee also talks about the decision maker considering the views of the child as a significant factor in the settlement of the issue if the child is capable of forming views in a reasonable and independent manner. So children should be allowed to express views freely, which means parents should not be manipulating them. Another part of it is, again, as I think Suzanne talked about this, children have to be informed about how their views have been interpreted and used, and provided potentially with the opportunity to challenge outcomes that have not adequately considered their views. And I'm just going to end with a quote from a decision from one of our courts from 2022, which I think is awesome and I refer to all the time. And it was a judge from Alberta in a parenting case who said, "The proper question in my view is, why should I not follow the child's wishes? If we accept that a child-centered approach in decisions of this nature is appropriate, the burden should not be on the child to prove why their views should be considered. The adults should have to demonstrate why what the child wants is not in their best interests. The international and domestic legal framework is not an abstract notion of justice for children. One must try to appreciate their lived experience through their lens, take their views seriously, and engage in a subjective consideration of what they consider important to them." So I think that sort of sums it up. But again, it comes down to the individual child. And if a child does not want to be placed in the middle of a conflict, does not want to express views, or does not necessarily want their views to be determinative, then you follow the guidance of that child. But if the child feels that their views should be given considerable weight in the outcome based on what they know to be their own experiences, then, my view would be that those perspectives need to be given significant consideration.
Thank you so much. And Dr. Saini, would you like to respond at all? I think you really, and this is just me as a moderator saying, while we pose those, I think as like a juxtaposition of position, they are probably not mutually exclusive. And there's a lot of nuance in relation to how you view the voice of the child. Do you have any final remarks related to that you would like to make?
Yeah, I mean, the way I explain it to parents talking about children's voices, it's like having two supervisors in your organization who hate each other, and you have to somehow mediate those two relationships and have a say about what should be happening to the organization. And so, yes, your voice is important, but you have to tread extremely lightly so that you don't upset the organization or get fired because your bosses are going to turn on you. And so it is a very precarious situation that children are in. And the only distinction that I would make here is that I think we need to unpack the word views. Where I see views, there's two major subcomponents. One is desires and one is needs. And so what is the child's desire and what is the child's need make up what we would consider to be their views, and that may be different. When we look at what they desire, it could be they just want consistency, they want predictability, they want what every child wants when their parents separate. And so what does that look like in terms of what they need immediately? It may be safety, it may be protection. And so we need to make distinctions of what we're talking about when we look at children's voices, because they're not all the same.
Thank you so much. We would like to open the floor for any participant questions. You can either put your question in the chat, or you can raise your hand and unmute and ask your question live. It's up to you, but we would love to hear what questions you have for these esteemed panelists.
While we're waiting for questions, if I can jump in too on this conversation, because I do think the law and case law in New York anyway, and I imagine in other jurisdictions, does guide judicial decision making on this question of the weight given to the child's voice. In New York anyway, there are many decisions actually of late increasingly overturning a lower court that fails to follow the wishes of an older child. So if that child is 15, 16, 14, the courts are increasingly taking sort of the position that Cathy was stating, which is that child would have a significant, not almost essentially determinative role in that decision, but that there's less weight given to younger children, and all of those decisions have to be in the context again of the law, case law, which does say, both parents have rights to access under, usually under usual circumstances, etc. So just from a judicial perspective, that has to be considered.
So one thing I would add is what Cathy was saying when she quoted the judge from Alberta. I really like the question being flipped as to why we shouldn't follow the child's wishes. Not that I would necessarily always be in agreement that we should, follow them, but too often, certainly in the jurisdictions where I've practiced, too many attorneys are questioning, well, what does a child know? It's just a child. This is not a decision for a child to make, and we don't need to hear from children. I think it's a nice way of turning the conversation on its head so that we have to kind of approach it from a different perspective.
Yeah, I really love that, Suzanne. Thank you. All right, I don't currently see any questions in the chat. Does anyone have any questions?
Hi everybody. My name is Karen Marino. I'm from Virginia. And so as a mom who lost custody of a child 3 years ago, I'm just surprised of everything that everybody talked today, because the issue that I had was that nobody believed what I was telling the professionals about molestation of my 5-year-old daughter. And so they will say that I was coaching her, and I committed alienation. I almost went to jail. And so I wish that at that time we had an attorney like some of you that are here that could hear the child. But if it's a 5-year-old, and I try to look for therapies, and they will say, well, maybe the child is confused. Well, she was having nightmares. She was having bad thoughts. She was having a really hard time in the house, to the point that I had to move because the neighbor couldn't handle her screaming and pushing and all of that. So, I mean, I think the proof was there, but it was not enough for the judge to say that, you know, she's in danger. Now she's living with the father, right? And now she's 8. My point is that how can we fix this? The problem that I face and a lot of women in the US, when we report abuse, it seems like we are trying to take children away from the fathers because we want all the custody. And they're not looking into the children actually, because they're taking the children from me, but by removing the child from the moms, they are taking away time with the mom too. So now they're with the father full time, but they're not with their mother at all. And so I think, and then they don't know what the father is doing. In my case, right now, I don't have a case, it's closed, but my daughter tells me my grandma cannot take care of me, so I have to go to my daddy's job who works with trucks, and I'm there until he finishes his job, and or I have to go to my friend's house, and so he's not able to take care of her after school. So I just thought, so nobody look at that, you know, they just look at what I did wrong, that I didn't send her on visitations. Now I pay child support. I have visitations, but a lot of the women, I'm part of a group of parents who lost custody in Virginia, and they have supervised visitations. They went to jail. We pay child support. It's just, it's very challenging, but I just feel like by hearing all of you, I think there is hope. There is hope, and maybe, you know, our cases, it's already done, but we can prevent this for other children. But I will continue fighting for my daughter. But I guess my question is, how do we protect our children when, like in my daughter's case, she said, "Mommy, you are the only one that I can trust. I cannot tell the school counselor about anything because they're going to tell my daddy and he's going to ground me."
I mean, I can comment on that. I mean, I'm sorry to hear that what you've gone through. I think, you know, in context of what we're talking about today, about children's voices, I think, you know, when we go to that well too many times in too many different ways, then children's testimony unfortunately becomes considered less credible in the courts. And so we need to wrap around as professionals so that when there are allegations, that we're not chasing allegations, but we look at these in a comprehensive, organized way. So we're not re-interviewing children multiple times, that we build a scaffolding of trust with children so that they feel more comfortable to share with professionals and tell their story once, not 1,000 times, where every time they tell their story loses credibility from an evidentiary point of view. And you're in a situation where children have stories to tell, but no one listens to them anymore because they're perceived to be as too biased, too influenced, too filtered by professionals, therapists, police, child protection, you name it. How many times has children been interviewed by multiple people, and we don't have an organized way of listening to children's voices, which is why I said, at this point, we all agree that children's voices should be heard, but it's how we go about doing that way that we don't agree on. And I think if we can develop credible ways of organizing ourselves, then we stop putting children through multiple interviews, which just doesn't help the situation. And it's tough on kids and it's tough on the parents involved.
So I would add to what Mike said, and thank you very much, Karen, for bringing up your case. I do think that in court cases that are being litigated and highly contested, if there's an allegation of child sexual abuse, I think it's particularly important that the child has their own independent advocate, because so often the protective parent, the parent who is bringing forward what the child may have said to them, is not considered to be reliable. And I think an independent attorney for the child who may bring forward some of the same evidence, but also from the child's perspective, with the court knowing that they're an independent advocate, you know, for the child and for the child's experience. I think that's the way we can actually have weight given to what the child's experience has been, since child sexual abuse cases are notoriously hard to prove in court anyway. There's so often no substantiation unless there's some medical evidence, which there rarely is. And so I think having a child's advocate attorney actually present what evidence there is, and these cases often are in a gray area, but being able to advocate for to explain to the judge, why is the child responding in this way to the parent who's alleged to have abused them, putting the documentary evidence in front of the judge and having it come from someone other than the protective parent, I think is very helpful.
They're great responses. Would any of the other panelists like to respond?
I mean, I think I would just echo what's already been said, that, I mean, there's an advantage to having independent representation because, you know, the lawyer for the child has no stake in the particular outcome other than, you know, the outcome that the child would prefer. And so they're automatically given more credibility than either of the parties who have a vested interest in the outcome. And you know, as Suzanne had referred to previously, that guarantee of confidentiality that the child's lawyer can provide to the client can make a huge difference to the child's willingness to share information. And so that then can assist the lawyer in terms of figuring out what kind of evidence needs to be gathered. Of course, you have to do it in conjunction with the child and in accordance with the child's level of understanding, which may be a little more challenging with a 5-year-old. But yeah, it sort of allows you to do some of the digging for the factual information that can then be presented in a way that's more neutral to the court and therefore more likely to be given some weight.
Thank you. We have a question in the chat. It says, in my state, we sometimes struggle with GALs not being trauma-informed in DV cases. With child representatives, I worry it would be the same scenario. What can be done to make sure that the child representative is qualified for a particular case?
Well, I guess it depends on the jurisdiction, but I would say that any lawyer that's representing children needs to have proper training. And again, I think Suzanne referred to, you know, what happens in her neck of the woods. There needs to be training on, you know, children's developmental stages, on trauma-informed lawyering, all of those things. And if that's not there, then yeah, there's a risk that the lawyer's involvement may not be sensitive to the child's circumstances and could potentially end up further traumatizing the child.
Sorry.
Go ahead.
I would just add that, you know, there has to be training. One of the things that I think is different between sort of the model that the three of us represent and the GAL model is that our lawyers are not standalone lawyers. So a GAL model, often, yes, they have to go through 12 hours of training or whatever, but our lawyers are full-time doing this. We control their training. We set training requirements. We train on domestic violence. Obviously, many of our attorneys come from domestic violence agencies or have worked in that field in the past, or in child protection, other related fields. So in addition to the, of course, trauma-centered lawyering, and also the law and statutes. So, you know, having an organization is I think critical to getting the level of training and supervision. It's not just training, it's supervision, having ongoing check-ins and oversight of cases. I forget, there was something else I was going to say, but
I'll just say quickly that I think trauma-informed practice is turning into a bit of a buzzword. And I think, the training that is required is to use those principles of trauma-informed practice, ensuring safety, empowerment, choice, collaboration, and ensuring that people really truly feel empowered. And this includes children. So ensuring that they're safe, to ensure that they have voice. Like, this is the trauma-informed principles that need to be embedded into training. It's not just fine to say we're focused on trauma, we're focused on adverse childhood experiences, but how are you actually implementing a trauma-informed practice with children? What evidence is there of those principles in play?
All right, we are at the top of the hour. Thank you so much for joining us. Ariana, I'll have you pop our contact information up onto the screen. This webinar was hosted by the Child's Voice Project. If you have any questions about the Child's Voice Project, would like to become involved, please reach out to us. Also, stay tuned. We will be hosting future webinars on more topics, and we are also going to be convening a monthly opportunity to get engaged and have some ongoing kind of panel discussions together about these different topics. Thank you again to folks who asked questions. We really appreciate your willingness to share and really, ask the questions that need to be confronted. I think it was quite lovely to have a person that actually had experience in the family court system ask a question, because so often we hear these stories, and I think our panelists did a very fine job of providing some really practical ways that we could move forward and make this a better place in the family court system. Again, thank you all so much, and have a lovely rest of your week.
Thank you.